express a warm welcome both to Professor Clarke and also to Lord Justice Longmore for attending this our third meeting and the last meeting at which we are going to be taking oral evidence. We did have a meeting last week with David Herzl, and it's just possible that you Professor Clarke, have read the minutes of that meeting. I don't know whether you have. You haven't. Well, it matters not. At that meeting we did discuss a number of detailed points. Today I thought we might start with your views and the views of Lord Justice Longmore on the more general question of the need for this bill and whether this bill actually meets the need. Having said that, and having expressed our welcome to you, perhaps I could ask you to say whatever you'd like to say on that subject.
Fine. Can you hear me well enough? I'm sometimes told I don't speak loudly enough. Please indicate. Is that?
If you move the water from the focus,
I focus in that direction.
Are they on? They may not be on. They have to be switched on in that corner, don't they?
They're all on.
Who knows about switching it on?
So, the sound engineer.
Is it switched on?
Mm-hmm.
So,
Yes, that's better.
Fine. Is that better?
Yeah, that's better, I think.
I think the main plus about this proposed bill is it turns the tables round. At this point in time, if any applicant for insurance, you or I, consumer or non-consumer, wants insurance, we are supposed to guess virtually what the insurers want to know. We're supposed to disclose all information which insurers deem to be material to the risk which they are being asked to cover. What this does is turn it round in the sense that there's no longer a duty of that kind to disclose. Effectively, the duty becomes a duty of the insurers to ask questions, or in other words, to tell people what they want to know. In some cases, it'll be very obvious, of course, if I've got a broken leg, whatever it is, it's clear that I'm a risk on travel insurance, we say. But in most cases, people really don't know what they're supposed to tell insurance industry. This should be changed completely, and would bring English law, incidentally, if it matters, much more in line with other Commonwealth countries and indeed with Europe. That, I think, is the principal virtue of what this bill puts through. Not the only one, but the principal one.
Yes. Well, I'm very grateful to you. I think we're all grateful to you for that, as it were, introduction. And perhaps I could ask members of the committee if there's anything they would like to ask on the more general questions you dealt with. Incidentally, I should say we're very grateful for the paper which you sent us in advance. Thank you very much.
I ask the question of Professor Clarke. How does he see in future the relationship between the bill which will be an act and the codes of practice within the insurance industry?
I think a possible source of confusion, I think they have been a source of confusion in the past, because there have been inconsistencies between the various codes and advice that people have received on this question, and the black law itself, indeed. Now, in future, obviously, interested bodies cannot be prevented or forbidden from drafting codes of conduct. One would hope that the bill that goes through, as it works out, will be clear enough to people that those who might draft codes of conduct will stay away from that area of insurance activity. But clearly, it must be possible for codes to be produced in future. So there's a potential for confusion, as we've had in the past, but I would expect it would be not as great.
Are you happy with that?
Thank you.
Thank you, Lord Davis.
Thank you, Professor. I think we can all see that, at least theoretically, the removal of the obligation of absolute good faith in the area of consumer insurance is a major change, a revolutionary change, you might say. But I'm trying to get a focus on how much difference is it going to make in practice. Because clearly, for many years, in accordance with the industry codes and the practice of the Ombudsman, absolute good faith not actually been enforced in the consumer insurance area. So what I'd like to know from you is, have you made any study, or are you aware of any study, or can you give us the results, the summarised or approximate results of any studies which indicate how many consumer insurance contracts have been voided by the courts on the grounds that the consumer concerned was in breach of the absolute good faith requirement in seeking and purchasing that insurance policy?
That's a difficult question. I think the short answer probably is none at all, because consumers cannot afford to go to the courts in the first place.
Well, it would be the other way around. You mean consumers simply accept their insurance company's voiding of their contract without leading to any litigation at all?
In many cases, they had no choice because of money. Then came the Insurance Ombudsman's Bureau and then the Ombudsman's Service. And I think a very important underlying feature of what we're talking about this morning is that people should be aware that if they're very unhappy with the way they are being treated by insurance, there is the Ombudsman's Service, to which they can go at virtually no cost. I think the bill only would work on the premise that this will be possible and people will be aware of this possibility. Am I answering your question? I'm not sure.
Not entirely. Can you give us any idea at all, any estimate at all, of the practical difference which this bill, if it passes into law, will make?
Only the one I tried to outline at the beginning, that instead of applicants for insurance, the American phrase, having to work out what they're supposed to say, and if they can afford it again, asking brokers or intermediaries to tell them what they should say, they now sit back and they wait for the insurers to ask them minimum questions.
I understand entirely what the effect of the bill is going to be. What I'm trying to do is to sort of get a focus on, as I say, get some understanding for, is what practical difference it's going to make. So there is, as far as you know, there is no quantified information, no quantified assessment of the extent to which consumers have been losing up till now as a result of the absolute good faith rule and the application of the Reinsurance Act to consumer insurance.
As far as I'm aware, the only answer to that question would lie with the Ombudsman Bureau now. They must have records of the cases that come before them.
Well, I could ask the government the question, because I assume and rather hope before the government prepares legislation, they ask themselves questions about the practical impact of that legislation. And they look and see whether any such studies have been made. But at least you, as an academic, are not aware of any such studies.
I'm not, no.
Thank you.
Other than have been published by the Bureau.
Now, I think next is Baroness Equithane.
Thank you. Professor, surely one of the big things from the consumer's point of view is that they will not feel as if they are uneasy, and not feel uneasy every time they look for insurance, because certainly, anecdotally, a lot of friends of mine have said, you know, you go into insurance and you never know, have you managed to ask the right questions of your broker, and what actually is covered. And it's a very uneasy area. It's not something that consumers normally go into feeling very confident unless they're insurance brokers themselves. So I would have thought that it is a case of much better for the consumer. It makes a huge difference because it actually takes the onus off the consumer and puts it right where it should be, with the people who are paid, after all, to operate the whole thing, the brokers and the insurance companies.
I would certainly say yes.
Yeah, and now...
could I just ask about reasonable care, which you have in your notes to us? Thank you very much for that. One of the things that has most infuriated consumers is questions to which there is not a sufficiently clear answer in relation to their particular sentences. And in asking him about proceedings of this bill, a case brought to my attention, a man whose wife teaches music at a school, and from time to time, particularly in the run-up to exams, she gives tuition at home, additional tuition, for which she charges a fee. Her household insurance has a question: is your home used as a business? Yes or no? Now, he has are 5 sessions, 10 sessions, 20 sessions a business, a fee is charged, and there is no room in the insurance policy for a maybe, or I don't know, or further particulars. when we come to reasonable care, what is the position of this man, his wife, and their household insurance?
Well, the bill doesn't tell you, doesn't answer that question. I don't think it can. In some countries, you have lots of subordinate information which goes with bills. This is not the British tradition. I'm not suggesting it should be. And I tried, I think, to make this point somewhere in that paper that on that sort of question, the mainly or wholly question of how you divide the line between consumer insurance and non-consumer insurance, there can be lots of cases on the borderline, like the one you just outlined. To come back to your specific question, that question would be regarded insufficient, I think, now by any tribunal in this country, short answer. And therefore, when you do get a borderline case, and all sorts of possibilities one can think of, in the end it will come back to the Ombudsman Service. If the insurer, if a determined insurer, for whatever reason, takes against a particular claimant and says, that's not consumer insurance, what does the consumer do? The only thing the consumer can do, if in a case like yours, is say, hey, let's go and ask the Ombudsman Service. It would be very important for the effective working of this bill.
Thank you very much.
Thank you. I appreciate a couple of questions. Just perhaps to follow up on Lord Davis's questions. Would you be aware of at least significant numbers of at least, I don't want to use anecdote because that suggests that they're just empty stories that haven't been investigated, but recognised by charities like, or organisations like which have demonstrated instances where people that have been caught that under the existing legislation. And when I was an MP, a case in my own constituency where that's mortgage insurance that was denied, that husband that's a breadwinner that had a heart attack and died. Some years ago, he'd filled out the insurance application forms and under medical disclosure had not mentioned that on one occasion that his doctor had suggested he might be depressed and given him a single prescription for a few weeks of Valium. And on that basis, that payment of the claim was denied. And had my particular constituent not had parents who enabled her to stay in her house and to actually contest the decision, she would have certainly lost the house, even if at a future point she was actually able to get the courts to recognise her situation and make payment on the claim. So, I mean, there are a lot of anecdotal stories, are there not, that have indicated the need for this legislation, even if we don't have a properly tallied set of numbers. And I just wanted is your understanding similar to mine?
With respect, that's not anecdotal. There have been many cases similar to that, the so-called pre-existing condition clause in many insurance policies. You can understand why the insurers put it there. That's not evil by the insurers. On the contrary, they have every reason for knowing as much as possible about the physical condition of the applicant in a situation like that. And indeed, I'm going slightly sideways if I may, if the bill works out with the turning of the tables, which I tried to outline, that situation will be much improved because the insurers will have to ask much more prominent, specific questions about my health when I take travel insurance or whatever it is. So that's often anecdotal, and that's precisely the sort of situation which we hope and indeed expect that a bill like this will improve.
And would it be your reading of the bill that were an applicant to fail, for example, to mention the instance that I just described, which clearly did not bear on the cause of death in any way, that under the new bill that the insurer would have to make payment? And indeed, if the condition were relevant, then simply to as it were, recast the insurance as it would have been had the disclosure been
unless
made.
The applicant were fraudulent.
Precisely. So we have the same reading then of the bill. So I just wanted to clarify that. Could I ask you about the area where I have significant concern? I have two concerns around industry code of practice. One is that this bill is intended to try and provide some genuine clarity for consumers. And are you in any way concerned that with sort of codes and the bill running in parallel but not identical, that we're losing an opportunity to get real clarity? And would you welcome some mechanism that tied codes back into the language, for example, as a test for reasonable care?
The short answer must be yes, I would welcome them. I can't for the moment work out how it would be done. It would be very difficult to do. As I tried to indicate earlier, the existence of too many pieces of advice and codes in the past was a source of confusion for consumers. And one would only hope that the bill will be so effective in its operation in the future that industry bodies, whatever body, whether the WITCH or whether the ABI, whatever, didn't spend too much time adding codes of conduct to the same area of consumer activity. But that must only be a hope.
And could I ask you just lastly, I mean, one of the concerns that I have, and I think that many people have in the field of insurance, is the issue surrounding genetic testing, particularly as insurance moves even farther in the direction of provision of long-term care, so that an insurer could understandably be asking very significant questions about underlying conditions or genetic predisposition. At present, at least those who belong to the AIB are prohibited from exploring that territory. So long as they remain members of the AIB because of the Code of Guidance. But as far as I can see, there is no mechanism that will prevent that being changed. Would you consider this bill to be one that ought to try and pick up that set of concerns? Or would you not consider it appropriate within this piece of legislation?
I think the last, it's not appropriate. It is, if you've given me a can of worms, this question. And it's such a big can of worms, it should be addressed quite differently. It's public policy as far as analysts and theories are concerned, which is a completely different chapter of any book on the subject of insurance. If they want to know about Huntington's disease or anything of that kind, I can well understand why they might wish to do so, but that does raise much wider and different concerns. And it would... Sorry.
Thank you very much, Dr. Soon.
Professor Clarke, in your opening remarks and in the helpful short note you provided to the committee, you referred to this legislation bringing UK rules into line with the rule generally favoured by European countries. And I just wondered whether you could shed any further light on how this approach has worked in practice in Europe, both from the perspective of the consumer and whether the insurer gets the information that's required under this approach, or whether there are any serious debates in Europe about going in some other direction.
Well, if I can come to the last first. Yes, there's been serious debate. I should be on an aeroplane tomorrow morning to Zurich to carry on that debate, but that doesn't answer your question. You will find that I think I footnoted a reference to the European project which I'm working on tomorrow, and the idea came most strongly, the idea of a specific question interrogation almost by insurers came most strongly from France, where they do have experience of this. So to try and answer your main question, yes, there is information about this. I know who to ask, but I certainly don't have it in my head. It has been studied in France, at least, if not other countries as well.
But you're not aware of any significant issues in Europe that would undermine our move to this approach?
No.
Thank you.
Any other questions for the professor? Yes.
Actually did say Commonwealth countries as well as Europe, did you not? And is there, to follow Lord Sassoon's question, is there any sort of evidence from Commonwealth countries where the law is more akin to our law than with Central European?
Or certainly. Straight in my mind comes Australia, for two reasons, or more than one reason, but among them the fact that in my impression is that the Supreme Court is now paying more attention to the High Court of Australia than to any other foreign Supreme Court, for good reason. I think they're right to do that. And there was a law reform commission in Australia which published about 20 years ago, I think, roughly speaking, in which these issues were addressed and discussed. And certainly my impression, again, that I can't quote chapter and verse at this time, is that one can pick out provisions of the Australian Insurance Companies Act, I think it's called, which are very much more in the direction of this bill than existing English law.
Lord Hodgson?
I wonder if I could just go back to Lord Sassoon's point about differences between practices here and on the continent. I'm told, I'm sure you'll correct me if I got this wrong, that the process for resolving difficulties in this sort of field on the continent, instead of the adversarial nature of our system here, relies much more on mediation processes which are quicker, easier to understand, and can be arguably user-friendly. Am I right in that assumption? And if so, would you think there's some value in us finding some way to consider a mediative process as opposed to the legal process as we know it, which has been proved to be quite long-winded and can be quite unpredictable and can be quite expensive and can be quite difficult to understand for the man in the street?
I think you may have in mind the interrogatory approach which is adopted in some countries. Again, it's France that comes to mind, in which a court official takes the initiative rather than the adversarial process of argument in front of judges. On the other hand, if you were asked someone like Lord Mustill, retired judge, he would tell you that there already exists in this country, and he's very much a fan of this type of approach, and a mediation, or what does he call it? I've forgotten the exact name, but he picks his words very carefully, but a non-adversarial way of solving civil law problems of the kind that we're talking about this morning. So nothing's going on here. And in my opinion, the Financial Ombudsman Service, in many ways, is providing that kind of informal resolution where they feel it is necessary and desirable.
Well, thank you very much. I think Lord Davis has one last question.
Yes, just following up on your comment to Lord Sassoon, Professor, that there is a lively debates going on in the European Union and the continent on these matters. Can you just tell us what principles are being contested? Can you just summarise the controversies, the active controversies that are going on in our partner nations on the continent?
Gosh, that's a difficult question to answer. I think if I had to try and focus on a particular point, which is close enough to this morning's business, they're extremely wary of warranties in English law. English law is regarded as much too severe, all or nothing, an absolutist in its approach to legal issues. And I apologize for repeating, one of the things this bill does, in my opinion, is to alleviate that, to soften the hardness of English law in the consequences. If I can focus on one particular thing, if an applicant is careless or not careful enough, and the answer is, instead of no insurance, there's some insurance. The remedies are not rescission or nothing.
Has the European Commission, to your knowledge, considered legislating on this area and producing its own directive? Because it occurs to me that it's not entirely consistent with the principle of a single market, that an insurance policy which is sold to a consumer in one member state may be an effective policy, but in another member state may be ineffective and avoidable.
Well, very much so. The Commission is currently concerned not so much with but harmonisation, I think, probably is the right word, and that in certain areas of activity it should be possible, for example, for a person who works in various parts of Europe to have life insurance which is valid in the same way wherever that person and his family find themselves working. And that kind of push is very much before both the Parliament and the Commission at this very time. The latest I heard was that general contract harmonisation might be too difficult, but one of the first things which they are thinking of working on at this time again is insurance contract laws, so that people, whether in work or as tourists, can find themselves in a similar knowable situation if things go wrong in France, Italy, Germany, or wherever.
So we may have EU legislation in this area very soon, and therefore have to revisit this area in order to implement the EU legislation in this country.
My understanding, sir, and I'm not an expert on this, is no. Legislation, no. What's called optional law. What they're working on is not law which they want all countries to legislate for, but optional instruments which parliaments may or may not choose to take as a sort of parallel second law. So if the UK Parliament were to do this, and I don't think it will personally, but if they were to do this, there would be common law operative or an optional instrument which insurance companies could put their policies subject to. Because for the insurance companies, the big advantage is they can sell the same policies in different countries. They don't have to look at the law in each country, all the many countries, before drafting policies and seeking custom. So it would suit both this, if it works, would suit both the consumer especially and the insurance company.
Well, I think it remains for us to express our great thanks to Professor Clarke for answering our questions so clearly and carefully. And I hope you will remain now while Lord Justice Longmore is put through the same process.
Well, thank you for listening.